questions. What is that?
You're fine.
The microphone.
Okay.
So your reaction to the judge's decision to accept that plea today?
Disappointing.
Extremely disappointing.
Very disappointing.
Just generally speaking, sort of the attitude in the court from the defense today about the family and your level of participation in the case, how did that strike you?
Totally disregarded. I mean, nothing on our side was taken into account in this whole deal.
It's all defense.
Yeah.
What the defendant needed, what his family needed, what, he was considered for all of his side, I think.
Yeah.
He didn't consider Wendy. Not at all. So
Yeah.
why should we consider him?
Go on. What was going through your mind as the judge was asking Ellis all of these questions and you had to sit there and watch that?
Procedure. It was a procedure. And the judge said that it was a procedure. I had to ask you these questions, and I want to, deter you by just saying, these are the questions I have to ask. So it's a procedure.
I was still really disappointed. Even now, he sat there when he was asked, "Are you going to admit that you're guilty?" Well, you said guilty, and he actually hesitated, put his head down, and I thought, "You've got to be kidding me!"
He wasn't
After
sure.
all of this.
He doesn't want to take responsibility.
Yeah. No, he's not.
Losing his right to vote,
Cowards don't.
who cares?
Yeah.
He doesn't care.
He took our 25-year-old daughter.
Left her for a week on the floor, decomposing, came and went every single day, stepped over her, fed his dog, walked his dog, left her there, didn't call for anybody. And her dad and uncle had to go and find her laying there, traumatized, on the floor, decomposed. After, you can only imagine what that does to a body. It is not right. And they want to cut his sentence in half? Really? No.
As the judge said today, he recognizes that he doesn't have to accept what the agreement is. He can go above and beyond that. So I guess as a family, what's your plan of action from here between now and October 20th?
We really want to see some justice for Wendy. We have not seen any justice being served during this whole case.
We hope that the judge can add on more time, because his discretion does not have to follow that thicker.
Judge Orlando had, in his sentencing hearing, he picked out everything. He knew that Ellis was, I'm sorry.
Evil.
Too much.
Total disregard for a human life, total disregard for how you care for a body, total disregard for Wendy, who he loved, total disregard. Went out for dinner, took himself out for dinner to Salty's, for dinner and drinks with a friend, and came back, stepped over her and said, "Oh, I called her to see if she was okay." I mean, if anyone would read the transcript, it is flat out.
I want to thank you again for your presence and your support and your assistance.
Thank you. Absolutely. Thank you.
We'll miss you.
I wanted to ask, would you have preferred this case go to a retrial at this point rather than have to deal with a plea agreement?
Absolutely. We have nothing to hide. He's the one that admitted it, point blank to the back of the head. This needs to get out nationwide. This is a problem with Washington state government, problem with domestic violence. It needs to get out.
And I think that was my question. You kind of touched on it there, but if the judge ends up sticking by the agreed upon terms, what message do you think that sends that someone can do what Joshua Ellis has confessed to doing and spend such little time in prison?
It just goes with the whole Seattle vibe right now. You can do whatever you want to do. Nobody's held accountable.
The consequences are minor.
Yeah.
Definitely.
Sends out a bad message to the public saying it's okay that you kill. Kill who you want. We're not going to slap you. We're not going to slap you around. We're just going to let you go.
Is there anything, I know it's probably hard to think past October 20th, but is there anything as a family that you've gone through during this process or learned during this process that you would be interested in trying to change, or any advocacy that the family has taken on?
Oh boy, that's a big question. I'm going to go off that topic just for a minute here. One thing that I'd like to point out, that for this man to be released from jail, this is a man that testified when he was asked if Wendy posed no threat to you, would you still have shot her? And he answered, I probably would have. So you tell me this is a man that's got a heart, that has a soul, and they want to let him out in 2 more years? I'm sorry, there's absolutely no justice for my daughter in this. There just is that she deserves way more than this.
I've had people ask me what my opinion was on this, just random friends and things like that, and every one of them came to the conclusion, what's gonna, who's next? Who's the next person?
Yeah.
Right.
If they let him out, is there a possibility it's gonna happen again? I'd say there's a likelihood
He's got
it's
such
gonna
a
happen
temper,
again. He's
yeah.
got such a bad temper that,
We saw it in court. In court, he
and
lost his
testimony,
temper.
and
Are there any like warning signs for young women who might be dealing with challenges in a relationship
Oh my gosh, yeah.
that you think that the public could benefit from hearing?
if you see something, say something. Even if it's the slightest hint, speak up.
Trust your gut. Trust your gut. You know
Yeah.
better. Your family knows better. It's okay to speak out. It's okay to be confrontational, and that you deserve better. She deserved better.
Get
We all
out.
deserve better.
She tried to get out.
Everyone in domestic violence deserves better than this. And this is so disappointing to see that a human life is so disregarded, and that you can get out in 10 years. No big deal. Go on. You get to enjoy your life. She doesn't. And every year, every birthday, every holiday, we're thinking of her. Every drive home when you're stuck in traffic and you want to make that phone call, you can't. Every birth, every moment, every wedding, she's not there. But he gets out. He gets to have all of that.
Wendy
It's
doesn't.
sad. It's terrible. And nobody should have to go through this. Especially have to go through this another time. How disgusting.
And as you were just know what's going on in court, the question of victims' rights, suspects' rights, I mean, what was going through your mind as you were hearing him talk about that?
Oh,
Where was her rights?
Yeah.
Where's Wendy's
Where's
rights?
the family's rights for
Yeah.
Wendy? No rights.
yeah, there's not.
We had to find our own counsel to help us. We were floundering around. We had nobody.
Again, disregard for the victim. Again.
And he was judged by his peers, and he was convicted. There's no doubt. And the judge said, I wish I would have could add more time to it. And now all of a sudden, he's getting less.
The plea deal was entered without us even knowing it. So, we didn't even know.
About that, this judge, he said at the end, the 2 court cases.
Oh, he's Judge Orlando was, I think he's, I don't know, how long was he,
Oh.
27 years on the bench, and he's had numerous murder trials, and he said, this is something he's always gonna remember. This was like the worst.
Heinous crime.
Heinous, leaving her there.
There was 2 cases he was remember, his first one and that one. Stevens was quoted saying, if I could give you more years, I would. So,
Yeah.
for a seasoned judge to say that in the first trial and to say how terrible this crime was means something. And the fact that they just threw all that out the window today, I mean,
Where's our
Where's the
justice
justice?
system? There's none.
And Alice got rid of his gun, got rid of his wallet, got rid of his phone.
How convenient.
So Ellis's mother walked by without a word. Has she tried to speak to you at all before?
No.
No.
Would you like to hear from her?
No. Actually, I take that back. We crossed paths going to the bathroom, and she said to me, I'm sorry for your loss. Okay. No, I'm sorry my son did this to your daughter. I mean, he has yet to apologize. Never once. All he has said to Mom, I'm sorry, Mom. I'm not going, nothing to us. He, no.
There's no remorse.
Nothing. Absolutely not. No remorse.
Jerry and I were at the murder scene, and we saw that with what we saw, the evidence there, and it appears that gun was placed there. And so.
Okay, good.
Thank you.
Thank you.
Thank you.
This stage, it's the state's contention that it falls within the court's general discretion as to whether the court wishes to hear from them at this stage with the same discretion the judge has to handle any hearing and what information the court does or does not wish to hear. What I can tell the court verbally right now, and what will be in my prosecutor's statement for the basis for filing the amended information, is that the family is diametrically opposed to the amendment. They are very upset with our office for agreeing to the amended charges, as well as the plea bargain and the sentencing recommendation, should we reach that place that the state will be making. The family is very frustrated about the lack of communication they believe in their lack of involvement in this negotiated settlement. I do have an obligation under the statutes to tell the court whether a family supports an amendment. And so I'm making that record both orally and in writing so that Your Honor knows how very opposed they are. And I'm then asking the court to exercise its discretion to choose to hear from a representative from the family. Their chosen representative is Ms. Ann Bremner, who is an attorney. And if the court is disinclined to hear from an attorney on their behalf, I can have a family member step in. But it is the family's request that you hear from them or their designee prior to accepting the amendment.
Okay. I have reviewed the motion, which addresses that issue. Ms. Hyde filed. But Ms. Hyde, if you want to briefly respond.
Yes, the court already has in the filing some statements from family members.
Let me just note for the record, I did review the victim statements that were filed yesterday, as well as an email. Sorry, I don't have an email that was sent to the court today, this morning, by another family member, and I apologize that I don't remember the name off the top of my head. But I have reviewed those. I believe that email will be filed as well.
Yeah, I haven't seen the email. I did see that late yesterday afternoon, a couple of statements came in, and that was what prompted me to file this with the court. I am objecting to having Ms. Bremner or family members address the court at this time with this proceeding. This is not within the purview of the Victim Rights Constitutional Amendment or RCW 769. It provides for notice, it provides for the opportunity to be heard at sentencing. They've been given notice, they've actually already weighed in with their thoughts for the court, with their emails and their victim impact statements. You know, I think for fairness to Mr. Ellis, his due process rights are not trumped by the family's desires. And, you know, the fact that they have the resources to hire an attorney, Ms. Bremner, doesn't really help. I will say, do not hear from the family additionally. You have 2 letters and an email, and you can make your decision regarding the amended information without further statements to the court.
Okay. I'm gonna accept the position presented by the state, which is that this is discretionary. And I think it's always helpful to hear from anyone who's so motivated to address the court, to the extent I'm allowed to. So I will hear from Representative the attorney, and it was
Ann Bremner.
And I would just like the court to be mindful, and Ms. Bremner, about the facts document they want to, I believe they'll probably want to go pretty far afield of what are the facts that have been acknowledged in this case, and so I'd just like the court to be mindful of that.
Okay, I will be mindful of that. Ms. Bremner.
Thank you. Do I go over here or over here?
There was a little bit of an audible laugh when it was said the family have resources to hire me to send for them. So I want to say that.
I will also just say, whether or not a family hires an attorney, if they didn't, I'd be hearing from a family member representative representing all of the family. So I don't think it really changes much in terms of family presence.
The family very strongly objects to this plea agreement, the plea bargain. And I'd like to start where the outset and saying, Your Honor, that I think the court has to consider whether this agreement is in the interest of justice and within prosecutorial standards. It's not in the interest of justice. They have a path by the agreement only on sentence. In a murder case that was based on a jury verdict, a sentence based on a jury verdict, a full trial. So it went from 23 years to potentially about 10.25 years. There's no basis for this. It's not an interest of justice. All of the evidence that was brought forth in the first trial can be introduced in this trial. We've never heard that there was any difference whatsoever in terms of the evidence or in terms of potential proof problems. The defendant testified and confessed. He testified under oath in the trial. And there's no lost witnesses, no lapse in terms of memories or anything else that would change the results potentially in this case. The statutes, and I can provide these to the court, it's not just the victim's rights, constitutional rights, but also the statutes under RCW. They are allowed to make an objection now. They would also like to be heard further. But the fact is that this plea agreement is not in any way acceptable to me. I don't know how much you read about the case, but Wendy Trainer was only 25 when she died. She was shot in the back of the head. She was had a life ahead of her. I'm actually shaking a little bit. I'm not sure why, but I just feel so strongly about this case. I might not want to ask someone else to do this, but I'm going to compose myself for a minute. It's just so upsetting, and I've seen the family just absolutely beside themselves about whether this case should be tried. And the defendant, stepped over her body for days. There was a dog in the house that was dead. Her family found her parts of her brain going out of her skull, decomposing. And then he had actually gone to dinner the night of the murder to Sultan's. This was domestic violence. He came from,
And Your Honor, this is where it's getting pretty far afield as to what the facts are in this case. If there's a legal basis that it
and I will just note that I'm gonna have, to the extent this goes to sentencing, the victims will all be heard, I think, much more extensively than at this hearing. I don't necessarily want to get into the facts themselves, outside of what's established in the record. But if there's more that you want to say, particularly with regard to any factual basis to support the amended information.
There isn't any, Your Honor. I mean, there's no basis to amend information. I was a prosecutor, I've been a defense attorney. There has to be a basis to amend the charge, and there's not. This has been pending since 2017. There's absolutely no basis, no factual basis to do it. And so to come here, especially when the family objects so much, that to come in and just say, well, we reached an agreement, so therefore it should be accepted, I think it's wrong. It's an injustice. And finally, victims' rights, as the court knows, have been around since the early 80s. And our Constitution says victims should have the same rights as defendants. But they don't. And you have to give meaning to that. I'd like for them to be here this morning too, at least from her mother and from her aunt. But they have not been insulted on a plea agreement. They have objected. They want to talk today. And I think it would be fair just to hear from them in their own words as to why they object. But legally, there's no basis for this. Factually, there's no basis for this. And we ask for it to be rejected.
I heard from a representative of the family as an accommodation, because of the desire to be heard, and the presence, which I appreciate. I'm not aware of any statutory right to be heard today at a plea hearing. So I'm gonna proceed with the hearing with the parties. And unless there's anything else.
Well, the statute that was cited to the prosecutor under 994 is basically that there is a right to have objections related to the court, which has happened, and we appreciate that. And you're right, Your Honor, of course, that there's some independent right of the family. I would note that around the nation in terms of victims' rights legislation, even in the Epstein case, that went up on the seal, and victims not being consulted about a plea agreement we had in Florida before this federal case. There's no reason to go forward with this. The family's ready for a trial, and we think there should be a trial. It's been years, since 2017. If Mr. Ellis is allowed to have this accepted by the court with credit for time served, and for also potential time off good time. This is a dropping of the deadly weapon enhancement. He'd be out for a homicide, a murder of a 25-year-old girl who was 7-star.
This is a difficult decision because I think that our state statutes present a protected place for victims and their families in the criminal process, and that includes the right to be consulted with regard to any plea agreements. It is, but it is limited to that, and that is in part because of the constitutional rights of the defendant to due process, which, as unfair as it may seem, does come first in our constitutional system that has been around since our Constitution was adopted. So, given that, I am going to accept the basis for the amended information presented by the state, and I will proceed with I will accept the amended information, second amended information, contingent on a successful plea this morning.
Thank you, Your Honor. We appreciate that. Just to let you know, Mr. Ellis has family members of support. So, just so you know, that there are people that care about him and are also really concerned at justice. I had a chance to review with Joshua Ellis the statement of the defendant on plea of guilty. He has his own copy. I have a copy here that we can follow along, but he understands that he gives up very significant constitutional rights, right to trial, right to witnesses, right for appeal. He also understands that by entering a plea of guilty, that it could have, it's going to have ramifications if there are any immigration issues, obviously voting rights and rights to possess funds. He also understands that this court will have a recommendation, all right? As you can see, it comes equally with no criminal. What happened in that first recommendation? So we are here fresh in front of you. This is strictly a noble process. He understands that this court's going to have discretion. He also understands that this is a strike offense, and he understands what a strike offense is. That is, if you get a certain number or do a serious offense, you can put a prisoner for the rest of the life. And then finally, like I said, the recommendation is a joint recommendation. He understands your goal with respect to that. And then finally, I typed out a statement regarding the amended charge of felony murder in the second degree, which he has initialed in the side. He adopts that to provide the court with a factual basis for accepting his plea. And he also understands he waits his right to remain silent to answer your question.
Mr. Ellis, I just heard from your attorney. I'm going to inquire directly of you. First of all, was everything she said, was that correct?
Yes, sir.
Okay. I have a statement of defendant on plea of guilty to a non-sex offense felony. Do you recall going over this with your attorney? Okay. And I see on page 12, there's a signature over the line that says defendant. Did you sign that?
Yes, sir.
Okay. And there's also a factual statement in paragraph, in section 11 on the same page. Looks like there are initials next to it. Did you go over those factual statements with your attorney?
Yes, sir.
And is that your initials in the margin?
Yes, sir.
One of my jobs this morning is to go over this statement of defendant on plea of guilty with you, and at times it may sound like I'm trying to talk you out of a plea, which is not my intent. My intent is to make sure you understand what you're doing by pleading guilty. Does that make sense?
Yes, sir.
Okay. because as it now stands, you're presumed to be innocent of the charge. And by pleading guilty, that changes, and then that presumption drops away, and you are then guilty. You understand? Yes. Okay. So I want to make sure that you go in with your eyes wide open with that. So first, let me just get some background on you. You're 33 years old. You have been through 12th grade and some post high school education.
Yes, ma'am.
Okay. And so you read and understand the English language.
Yes, ma'am.
Which is of course important because this statement is written in English and you were able to understand it.
Yes, ma'am.
Okay. Were you able to ask your attorney all the questions you had about it?
Yes, ma'am.
Okay. So you understand that the purpose of this statement is to enter a plea of guilty to the charge in the second amended information for felony murder in the second degree. You understand that?
Yes, ma'am.
Okay. And you understand what the elements of that charge are, what the state would have to prove beyond a reasonable doubt if this were to go to trial.
Yes, ma'am.
You also understand the evidence against you, what the state would present at any trial.
Yes, ma'am.
Okay. And you understand that you're giving up a number of important rights by pleading guilty, constitutional rights that would continue but for your plea guilty. And those are laid out in page 1 of the statement. You understand those rights?
Yes, ma'am.
Okay, I'm going to go through those one at a time just to make sure you get them all. You understand that you're giving up the right to a speedy and public trial with a jury. You're giving up the right to remain silent during trial and the right to refuse to testify against yourself.
Yes, ma'am.
You're giving up the right to hear and question the witnesses who would testify against you.
Yes, ma'am.
You're giving up the right to testify for yourself and have witnesses testify for you at no expense to you.
Yes, ma'am.
You're giving up the right to be presumed innocent until the state proves its case beyond a reasonable doubt.
Yes, ma'am.
And you're giving up the right to appeal a finding of guilt. Okay. Did you go over what the standard range would be in a case like this?
Yes, ma'am.
You understand that the standard range would be 123 months to 220 months, and a term of community custody of 36 months. And you understand the importance of the standard range for purposes of sentencing. You also understand that there's a maximum term of up to a lifetime in prison and up to a $50,000 fine.
Yes, ma'am.
Okay. Your offender score is 0. You understand the importance of that for sentencing.
Yes, ma'am.
And you understand, when I mentioned community custody, you understand that means that even after release from prison, there would be certain limitations on your freedom during a term of community custody.
Yes, ma'am.
The prosecutor in this case is going to be recommending a low-end sentence of 123 months with credit for time served, no contact with the victim's family, and certain legal financial obligations, DNA collection, and restitution, if any. You understand that recommendation?
Yes, ma'am.
And do I, as the sentencing judge, have to follow that recommendation?
No, you do not.
Okay, you understand that I can sentence you to the maximum allowed by law.
Yes, ma'am.
You understand that if you're not a citizen of the United States, your plea of guilty could lead to deportation, exclusion from admission, denial of naturalization, or otherwise exclude you from the United States.
Yes, ma'am.
You understand that your right to possess a firearm under state law or a firearm or ammunition under federal law will be lost with this guilty plea.
Yes, ma'am.
You also understand that your right to vote will be lost during any period of confinement.
Yes, ma'am.
You also understand that you may be required, I mentioned the DNA collection, you will be required to give up a sample of your DNA.
Yes, ma'am.
You also understand that you may lose any government assistance programs during your period of confinement.
Yes, ma'am.
You also understand that this is a strike offense, and that if you have 2 subsequent strike offenses, you would be placed in prison without the possibility of parole for the rest of your life.
Yes, ma'am.
I mentioned the factual statement on page 12. That reads that in the state of Washington, on or about November 3rd, 2017, while committing or attempting to commit assault in the second degree arising from an argument with Wendy Traynor, during which we were both armed, and in the course of furtherance of assault in the second degree, I caused her death. I assaulted her by intentionally shooting her, which recklessly inflicted harm, resulting in death. Are those the facts that you're admitting today?
Yes, ma'am.
Okay. Has anybody made any threats or promises other than what's laid out in this statement of defendant on plea guilty? Okay. Do you have any questions about this plea before we move forward? Okay. Does anybody have anything they wish to add to the record?
No, Your Honor. No, Your Honor, we definitely accept this plea guilty.
Okay. Then as to the charge of felony murder in the second degree, as charged in the second amended information, how do you plead this morning? Guilty or not guilty? Okay. I find that your plea is knowingly, intelligently, and voluntarily. I find a factual basis to support the plea, and I'll sign the statement of defendant on plea guilty. The next contentious question in this case is when sentencing would be. I understand that there's a conflict with the defendant's family versus the victim's family. I noted the statutory right of the victim's family to be heard in sentencing. I don't see a similar protection for the defendant's family to be heard in sentencing. I understand that certainly would be appropriate to hear from the defendant's family, but in having to weigh those two, I don't weigh them through. So I'm going to go with the October 20th date to leave for the victims.
And with that, so perhaps we could have administration set up a Zoom or a remote.
I understand. I understand that might be necessary as well for the defendant's family to also, I think, request by the victim's family. I will do my best. We do not have a hybrid courtroom. I don't know if it's possible to set it up for the hearing or to switch courtrooms on the day of. We're exploring that. But I will do my utmost to ensure that whatever technology is available to make sure people are heard and can participate, that will be available.
And Your Honor should also have before you proposed conditions for release pending that sentencing date that do hold Mr. Ellis within the bail hold. Given that October 20th will be beyond speedy sentencing, we need to have a waiver of speedy sentencing in front of defense or the court finding good cause to set this beyond the 40-day period. And there's a box in the conditions of release that can be checked if the defendant grants a waiver. If not, we will want to interlineate on the conditions of release and likely on the schedule order if the court is going to find good cause to waive speedy sentencing.
You know, this puts us in such a difficult position, Your Honor, and that we've tried to accommodate the family over dates for the police and over dates for the sentencing. His mother flies here from the East Coast for each one of these. If perhaps they could just work to accommodate with us as well, would be appreciated, rather than having this request that he waive the speedy sentencing to accommodate them, which would exclude his mother from being present.
Well, what I will do, if there's as some sort of compromise date that might work between now and October 20th, I would only hope that everybody would be, it might be a lot to ask for people to be reasonable under the circumstances, but
And I can tell the court that there is not. Before the court came out, we spoke with the parties to see if we could find a date that worked. The family cannot do early September because someone is out of town. We discussed the September 15th date, and it sounds like there are some plans in flux, and it's not fair to ask the family to have to change their plans or cancel trips when they are the ones that have the constitutional right to address the court at sentencing, as the court has already noticed. I am not available in the court's earlier sentencing date in October, and I believe Your Honor is also potentially on recess. So I believe the only appropriate date before the court is the October 20th date to accommodate schedules and the family's constitutional right to be heard. And that is a sufficient good basis the court can find to waive speedy sentencing. That is what the state is asking the court to do.
Your Honor, if I may, Washington Constitution, Article 1, Section 35, talks about a representative. Doesn't talk about making sure you accommodate 20 individuals to address the court, but rather a representative of the deceased. I know that we've seen from several family members, but if there's a remote possibility, they could appear by Zoom, because I don't presume that even under the constitutional amendment that it means that 20 people get to address the court as our local statute. And the constitutional amendment says we're talking about otherwise that they have a victim's representative up here. So we're talking single. I don't know, like I said, we routinely look at community members, but for those that perhaps are saying, hey, I can't do this because I have some plans for in flux, they can provide a victim impact, and there can be a designated representative.
The only thing I want to add, Your Honor, is the person that indicated they had plans that were in flux is Wendy Trainer's mother.
Okay. I know that I have some flexibility in how I hear from the victim's family. I want to do my utmost to accommodate anybody from the victim's family who wishes to address the court. I understand that the victim's family already has dealt with a lot in today's plea, and the very least I can do is hear from them and sentencing. So I'm going to go with the October 20th date. I find good cause to delay the sentencing to accommodate the victim's family. And I'll sign the scheduling order when it's available.
And may I just try to determine, we have looked at dates in September because his mother is available that entire month. I think we talked about the 21st, but I don't know about, say, September 22nd or September 29th. I know that we're trying to accommodate Ms. Brenner's trial schedule, and she would be available on a Friday, so I'd like to put that out there to see if we can have some accommodations with his mother as well.
I think one of the limitations I have is that I can only do criminal sentencing every other Friday because of other matters that get set on my Friday afternoon, and this is going to be at least a 2-hour sentencing. So,
Could we do a morning, or is that going to be your civil docket?
that will be my civil docket in the morning every Friday, and trial on weekdays. So, on Monday through Thursday. So, unfortunately, I think I set my own limitations on when we can schedule this.
I am not. No.
That's the 4th Friday, which is why I set for something. So, I'm gonna ask the jail, you being the representative, they, our sentencings for Department 23 are for the first and third Fridays every month. The 22nd of September is the fourth Friday, so I would be set for a family law settlement conference, but if, assuming I can find somebody else to handle that, would the jail be able to accommodate a sentencing on that day?
I'm not here then.
Okay, and I understand, it looks like the, Ms. Bremner wants to address the court on the scheduling.
I do.
I can tell the court that I attempted to communicate via lip reading with, Ms. Black, with Ms. Trainer's mother, about whether that would run afoul of the same issue as the 15th, and I received a head nod in response. So my understanding from what I'm getting from the family is that date was closed.
I can't get it to open.
Ms. Bremner.
God bless you.
Okay.
She can come in.
Thank you.
To address the issue.
I couldn't tell if it was a tough door, Your Honor, or I was just weak on it.
Thank you. I am unavailable on September 22nd, that's the day that's being considered. I am in a Nanny Alice trial, starting September 18th, 12 weeks here in with one of the officers. But I'm out of town on the 22nd for that weekend for a speech in Florida. We're not in session, of course, on Fridays.
29th, are you available, Ms. Griffin?
Well, I want to be available when my clients are available, which I thought was the 20th.
Oh, that's right. Sorry, I'm not,
Okay.
I don't know.
We object to setting outside speedy. He of course said that the Alex meeting. And so I'm just gonna make my record here that we object to the setting of this sentencing. And, if there's something that the family members, if there are an additional date that we can make work, I would like to get that. Because I find that it's really important that Mr. Ellis be supported as well. Meaning that Mr. Ellis wants, his support in the courtroom as is important and as a due process, right? If we're going to, race on, other individuals that have an interest in this case.
Well,
It's sentencing.
right, I'm gonna set it for October 20th. If the parties can find a date between now and then that works for the court, I would certainly consider, scheduling it an earlier date. But I need to find you on a good cause, setting the scheduling over the court. And also, I was assuming there was no objection to the order establishing conditions pending sentencing.
Other than the setting of the sentencing date.
Okay, I signed that proposed order. I also have the stipulation on prior record, which is signed by the defendant and defense counsel, but not by the state, so I assume that one is stipulated.
Yes, sir.
Is there anything else?
And Your Honor, as we prepare for sentencing, I guess, will you perhaps provide us with some guidance or guidelines on how many people will be addressing the court? You know, I'm not sure what your preference is. Often there are limitations. I mean, certainly not limitations on letters that the court can receive or statements, but often in terms of who can address the court and the length of that. If we could just know beforehand, I would really appreciate that.
Okay, that would be helpful for me to put my head together with my judicial assistant and get some specific guidance.
Yeah, the only thing the state will note is that, given the posture that we're in here and the family's very strong feelings, it's the state's request that the court hear from as many people as possible.
Right, and then that will be an overarching goal and schedule.
Thank you.
Okay,